Thank you very much. I feel very honored to be here today. Taiwan is really one of my favorite countries, and I'm always very happy to be here. I'm grateful also to Dr. Hong for inviting me, and to all his DC who have made the last few days very interesting for me. And I hope I shall go on visiting Taiwan for a long time. I may not have a long time, but I still hope. I call my paper, When Human Rights Become Human Wrongs. The vast majority of states around the world are signatories of international declarations on the subject of universal human rights. And nearly all of these pay lip service to the concept of freedom of religion. However, the ways in which the concept of human rights is understood and implemented differ enormously. And I would suggest that there are few, if indeed any, states in which the possibility exists for all individuals and/or all religions to be able to manifest their beliefs without some sort of prejudicial interference from the very states that have signed such declarations or from its agents. I am not a lawyer, but a sociologist of religion who has been studying minority religions and spiritual and philosophical groups and social reactions to such movements for over half a century. It has become clear to me that there are numerous ways in which the legal philosophies of states can be distinguished. And one classificatory distinction could be between what I want to call before states and after states. Before states have a policy of enacting laws so that their citizens will be protected from potential harms by a minority movement before such harm has taken place. After states, on the other hand, allow citizens to act relatively freely, but apply a universally applicable law about, for example, murder, theft, fraud, or child abuse, only after the law has been broken. In other words, before states have laws that prevent either some or all minority religions from manifesting their religion in a number of ways, or possibly altogether. Conversely, after states are unlikely to have any laws about particular religions or their members that don't apply to the general population. It is only after a religion and/or its members are proved guilty in law of breaking a general law that any restrictions or punishments will be imposed on them. They are, in other words, assumed innocent until proved guilty. Of course, these two types, before and after states, rarely, if ever, apply unambiguously in reality. Most states will be more or less before or after in their policies. However, it's possible to suggest that democracies are more likely to be after states than either theocracies or communist or socialist states, which are more likely to be before states. Examples of democratic countries, such as those of North America, Northern Europe, Australia, Japan, South Korea, and Taiwan, would seem, at least prima facie, to be more likely to be after states, while North Korea, mainland China, Vietnam, Russia, and Iran are more likely to be before states. But almost as soon as we make this distinction, we start to run into difficulties. France, for example, is undoubtedly a democracy, but it has passed a number of laws that might seem to place it firmly in the before category. Interestingly, given the situation in which Taipei has found itself, the French courts claimed that money donated to Jehovah's Witnesses was not eligible for tax exemption because it was not a real religion, but a cult. Eventually, however, the European Court of Human Rights overruled the French parliamentary decision, and the witnesses were repaid all of the taxes that they had been forced to pay. Indeed, once one starts to look at actual practices, we can see that there are a number of ways in which the law can be misused or circumvented by what are apparently afterstates in order to curtail the free practice of certain religions, or at least make it difficult for them to realize their constitutionally guaranteed legal rights and freedoms. England, which is clearly a democracy, and according to its laws, fairly obviously an afterstate, does have an established church, the Church of England, but it's unnecessary for other religions to register. All are free to practice in whatever way they wish, or not to practice any religion at all. However, if religions want to gain certain tax exemptions, then they have to register as a charity, though this is entirely voluntary, and some movements prefer not to apply for charitable status. Until fairly recently, it was assumed that all religions could qualify as a charity merely by being a religion. But then some unpopular religions, and the Church of Scientology as an example, were declared to be not real religion and were therefore denied charitable status. Even more recently, charity law has been changed so that a religion not only has to prove that it is a real religion, but also that it is of public benefit. The Plymouth Brethren Christian Church was deemed not to be of public benefit, although it was not accused of having committed any crime. However, a few years later, it was able to convince the charity commissioners that it did not cruelly ostracize their members from former members of their own families. Staying in the UK, at the time of what are referred to as the Troubles in Northern Ireland, several movements, such as the Irish Republican Army, were banned as terrorist organizations. But since then, a number of religious organizations have been banned, mainly Islamic jihadist groups such as ISIS or the Mujahideen, but also some right-wing Christian movements. In Lithuania and several other countries, there are various levels of recognition. All religions can practice freely, but according to the length of time they have operated in a country and/or the number of members that they will have more or fewer benefits, such as tax relief, access to public media, or being able to teach their religion in the schools. One way in which rights of religions can be denied is by labeling them in a certain way. Some are denied consideration as a religion because some other description takes precedence over that of religious. In mainland China, for example, some organizations are labeled Xizhao, which I gather really means heterodox teachings, but is often translated as dangerous cults. This means they cannot be regarded as a freedom because they are considered criminal organizations just because of the label and are subject to imprisonment and other punishments. In Russia, certain texts, such as the literature produced by the Jehovah's Witnesses or written by the Islamic scholar Said Nursi, are considered extremist because, for example, the Jehovah's Witnesses claim that they are the true religion, So everyone reading such literature is subject to criminal proceedings. But one might ask, which religion claims it is not the true religion? Yet another way in which the religious freedoms may be denied despite their legal rights is by the administrators of justice, simply not following the law. In the United States and Western European democracies in the 1970s and 80s, there were literally hundreds of cases of deprogramming. That is, illegally kidnapping converts to unpopular religions and holding them against their will until they managed to escape or convince their captors that they had renounced their faith. In such cases, the religions might complain to the authorities, or the person him or herself might manage to contact the police. But frequently, the police just turned a blind eye and might even collaborate with the deprogrammers in keeping the captor from returning to his or her religion. In one case in the United Kingdom, the Unification Church brought a case of habeas corpus in an attempt to set one of their members release one of their members from deprogrammers. But the judge just ruled that this 28-year-old woman was being held because her parents were concerned about her belonging to a dangerous cult, such as the so-called Moonies. And they, the parents, were good people who were clearly doing the best for their daughter. Consequently, the daughter was held for a month or more in a remote part of France, having at times been threatened at gunpoint. Eventually, she was able to return to her church, but it took some time to repair her relationship with her parents. The deprogrammers, who, together with the media and the so-called anti-cult movement, had convinced the parents to spend thousands of pounds on her deprogramming, were able to walk free with a considerable sum of money in their bank accounts. From what I understand of the case of Taiji men, it would seem that this is a situation in which an organization has been denied what is its legal rights by part of the apparatus of the very government that has declared its rights are being abused. Dr. Hong has been detained without justification, as clearly stated by a Supreme Court decision. And the movement has had tax bills imposed and land confiscated by the tax authorities for reasons that other sections of the government have declared illegal. And yet, Taiwan is a democracy, which is in many ways far more clearly an after-state than many other countries in the region or indeed throughout the world. In other words, it would seem clear that Taiwan is falling below its own standards as far as the Taiji men case is concerned. This is, to say the very least, a shameful situation so far as the rule of law and the rights of not only Dr. Hong and Taiji men's DC, but also of Taiwan itself. The rule of law is believed by most people to be a good thing, but that is only the case if the laws are just and fair, and if they are followed honestly by legislators and implementers of the law, rather than being perverted for perverse motives. I very much hope that Taiwan will, after all these years, put its legal house in order and remedy what seems a most unfortunate anomaly, when the tax officials can ignore the state's own pronouncements. Thank you.